show, we'll discuss question number 13, that is, discuss the principle sometimes referred to as feeding the grant why estoppel. So the very answer to this question we found under section 43, which deals with Transfer of Property Act 1882 regarding feeding the grant by estoppel, and as it is evolved by the courts of equity, it may be either by record or by deed. And as regarding that, the Section 43 of Transfer of Property Act is based on the principle feeding the grant by estoppel, a doctrine evolved by courts of equity in England. Estoppel may be defined as an admission by which a person is precluded or prevented from bringing evidence to controvert it or prove the contrary. It may be by record arising from judgment or by deed. The doctrine of estoppel by deed has been explained thus: where a grantor has purported to grant an interest in land which he did not at the time possess but subsequently acquires. The benefit of his subsequent acquisition goes automatically to the earlier grantee, or as it is usually expressed, fits the estoppel. So, in that correct relation, we will discuss the important leading case Tilakdhari versus Kedan Lal in 1920. It was the expression of Lord Buckmaster, who stated that the rule of estoppel why did as follows: if a man who has no title whatever the property grants, and he subsequently acquires an interest sufficient to satisfy the grant, the estate instantly passes. The principle is also based on the equitable doctrine, namely, equity regards that as done which ought to be done. So, Section 43 embodies these principles subject to certain qualifications, and will discuss those principles, such as where a person fraudulently or erroneously represents that he is authorized to transfer certain immovable property and profess to transfer such property for consideration. Such transfer shall, at the option of the transferee, operate on any interest which the transferor may acquire in such property at any time during which the contract of transfer subsist, and the second one, that the transfer must profess to transfer for consideration, and that is execution of a sale deed or hand about the title deeds. Right may be exercised by the transferee till the contract is merged, extinguished, otherwise comes to an end. So, the general rule is that a transfer by an unauthorized person does not pass a good title to the transferee. But if the conditions laid down in the above section are compiled with, the transfer holds good. So, firstly, there must be a fraudulent or erroneous representation. The words fraudulently or erroneously represents make estoppel the foundation of this section, and in the absence of such representation, the section does not apply to misrepresentation. Whether representation was erroneous or fraudulent is a question of fact. The transfer is entitled to the benefit if he was misled by the representation. So, accordingly, where true state of fact is known to the transferee, there is no representation. So, in the leading case that we would like to discuss, Bhagwan Din versus Muhammad Yunus Khan in 1934 won Asghari Begum mortgages a 4 annas out of 8 annas share to the mortgages. He was entitled to only a 2 annas share. Later, by a Rajinama, she was given 2 annas share in addition to her share. The mortgagee brought a suit under Section 43 Transfer of Property Act and claimed the sale of the entire share of 4 annas, basing his right to 2 annas subsequently acquired by the lady. Under the compromise, it was proved by evidence that the mortgagee at the time of the mortgage knew that she was entitled to 2 annas. It was held that where truth was known, Section 43 does not apply. And now we'll discuss another important leading case in this connection. M. Ratnam versus Srimati Sushila Lama. In 2010, the Karnataka High Court decided that both the parties believed that allotment order by the development authority of the plot of land gave full ownership to the seller. Seller knew he could sell and buyer knew she could buy. There was no representation otherwise from the seller to the buyer to the fact that he could pass ownership to buyer or that he was absolute owner. The letter of allotment was shown by seller to the buyer. It was a case of mutual mistake of fact. It was on a matter essential to the agreement. The agreement as such was void as under Section 20 of the Contract Act and was not enforceable as it was decided in this leading case by the Karnataka High Court in 2010. M. Ratnam versus Srimati Sushilama. So, in another point, that is second one, the transferor must profess to transfer for consideration. For example, execute a sell deed or hand over the title deeds. It operates only to the transfers of properties for value and not to the gratuitous transfer. And the third relevant point is that the right may be exercised by the transferee till the contract is merged or extinguished or otherwise comes to an end. Thus, where the transferee has sued the transferor for misrepresentation and obtained the damages, the contract is extinguished, and this section cannot be invoked in case the transferor acquires any interest in the property subsequent to the vendor made a transfer when he was not Bhumidar. and the right which he acquired under orders of the court was subsequently lost. So this provision is not applicable as it was decided in 1970 in the leading case Ram Dulari versus Dhila. And now we will go to transfer forbidden by law. And regarding transfer forbidden by law, this section will not apply if the transfer is invalid as being forbidden by law or contrary to public policy. A mortgage made by a disqualified person does not therefore becomes valid on that person ceasing to be disqualified. Similarly, the interest of a Hindu revisioner is specie successionis, which is inalienable. So the full bench of the Madras High Court in the leading case, Juma Masjid versus Kodi Manindra in 1953, the full bench of Madras High Court has held that even in case of species succession is the transferor is precluded from questioning the validity of the transfer if he later on acquires interest in the property. So, in another important leading case, that is also Juma Masjid versus Kudi Manindra in 1962, Supreme Court held that to hold that the transfers by the person have only a species succession is at the date of the transfer are not within the protection afforded by Section 43 would only destroy its utility to a large extent, as it was decided by the Supreme Court in this important leading case as to explain the very applicability of Section 43 of Transfer of Property Act, which deals with feeding the grant by estoppel. So, where a Hindu female was given life estate in certain joint family property in lieu of her right to maintenance in a partition, though with a restriction against alienation, the transferees of her property would not get any interest in her property in consequence of transfer effected by her stepsons and husband before the commencement of the Hindu Succession Act. The stepsons and husbands being mere revisioners, and the interest of a revisioner being a mere species succession is within the meaning of Section 6 of the Transfer of Property Act. Transfer, therefore, was a nullity. Further, at the commencement of the Act, the female would become full owner of the property in spite of restriction against alienation, as the case would fall within subsection 1 of Section 14 of the Succession Act. As the property was given in a recognition of the pre-existing right of the female to be maintained out of the family property, and the right of the revisioners would get extinguished. And now, in this context, we would like to discuss that the section 15 Clause 1, subclass B of the section Hindu Succession Act. Moreover, in such a case, the transferees would not be entitled to get the benefit of Section 43 of Transfer of Property Act even when the property is devolved on the stepsons of the female. The transferors on her death in consequence of Section 15, Clause 1, Subclause B of the Succession Act, as he had no daughter. When the transferees had full knowledge at the time of the transfer that the transferors had no title to the property, the transferees could not be said to be misled by any misrepresentation of the transferor, as it was decided by the Odisha High Court in the leading case E. Adi Narayan versus Rameshwari in 1980 by the Odisha High Court. So, where the transfer and also relating to minors transfer of movable property, section 43 provides that feeding the grant by estoppel, and in regards to that it would not be applicable, and where the transferor transfer the right to succeed and the transferee knows that it is a transfer of species. Succession is it is void under section 6 A Transfer of Property Act, and section 43 will not apply. So this should be the correct and relevant answer to this question which we have discussed. The very principle, and that is feeding the grant by estoppel as provided under section 43, and in relation to that we almost discuss 7 important leading cases. So also the very provisions of Section 14 of the Succession Act and Section 15 subsection 1 subclass B of the Succession Act, and so also the very provision as provided under Section 6 of the Transfer of Property Act 1882 to establish feeding the grant by estoppel, and in what condition and under what circumstances it would not be applicable, that also we have discussed in this particular answer relating to this question number 13, discuss the principle sometimes referred to as feeding the grant by estoppel. So, in our next question, that is question number 14, and that is what are the consequences of transfer by a co-owner of his share in movable property as provided under section 44 of the Transfer of Property Act? We would like to discuss the very answers to this question in our upcoming video.